Rule 9. Effect of failure to plead. Section 1. Defenses and objections not pleaded. Defenses and objections not pleaded, either in a motion to dismiss or in the answer, are deemed waived. However, when it appears from the pleadings or the evidence on record that the court has no jurisdiction over the subject matter, that there is another action pending between the same parties for the same cause, or that the action is barred by prior judgment or by statute of limitations, the court shall dismiss the claim. General rule: defenses or objections not pleaded in a motion to dismiss or on answer are deemed waived. If you do not plead your defense, the same is deemed waived. The court has no jurisdiction over the issues. Example: in a collection case against you did not raise the defense of payment in your answer, but during the trial, you attempted to prove that the loan has already been paid. That cannot be done because the defense of payment is deemed waived because you did not raise it in your answer. In other words, the court never acquired jurisdiction over the issue, so there is no such thing as a surprise defense because the defense must be pleaded. If you do not want to surprise the plaintiff during the trial by not raising your defense in your answer, you will be the one who will be surprised because the court will not allow you. When the parties go to court, the plaintiff already knows what are the defenses. They are already in the answer. Exceptions: what defenses or objections can be taken cognizance of by the court despite the fact that they are not raised in the motion to dismiss or answer. Under Section 1, Rule 9, the following: 1. That the court has no jurisdiction over the subject matter. That there is another action pending between the same parties for the same cause, litis pendentia. That the action is barred by prior judgment, res judicata. And 4th, that the action is barred by statute of limitation or prescription. Take note that the exceptions can be raised at any time during or after trial, or even for the first time on appeal. In other words, the court shall dismiss the claim if any of the foregoing grounds appears from the pleadings or the evidence on record. These defenses may be raised at any stage of the proceedings, even for the first time on appeal, except that lack of jurisdiction over the subject matter may be barred by laches. Tiham versus Sibong Hanoi, GR 21450. Now, the traditional rule to remember, notwithstanding the Sibong Hanoi doctrine, is that when there is a defect in the jurisdiction of the court over the subject matter, the defect can be raised at any stage of the proceeding, even for the first time on appeal. Rojas versus Rafferty, 37 Phil 957. This is because everything is null and void. Jurisdiction over the subject matter cannot be conferred by agreement between the parties, by waiver, by silence of the defendant. Litis pendentia. Illustration: you will file on another case while another action is pending between the same parties for the same cause. That is actually splitting a cause of action because there is already an action and then you file another action. The action can be dismissed on the ground that there is a pending action. A pending action to annul a mortgage is not a bar to an action for foreclosure of the same mortgage, for the reason that although the parties are or may be the same, the rights asserted and the relief prayed for in the two actions are dissimilar. A plea of the pendency of a prior action, litis pendentia, is not available unless the prior action is of such a character that, had a judgment been rendered therein on the merits, such a judgment would be conclusive between the parties and could be pleaded in bar of the second action. The rule is applicable between the same parties only when the judgment to be rendered in the action first instituted will be such that, regardless of what party is successful, it will amount to res judicator against the second action. Hong Kong Shanghai Bank versus Aldecoa and Company. Res judicata. There was already a prior final judgment, then you will file another case regarding the same issue. That is also splitting a cause of action. Prescription. is not found in the old rule, but is taken from decided cases, among which are the cases of PNB versus Perez and Pepsi Cola versus Quanson, held the rule on waiver of defenses by failure to plead in the answer or in a motion to dismiss does not apply when the plaintiff's own allegations in the complaint show clearly that the action as prescribed. In such a case, the court may motu proprio dismiss the case on the ground of prescription. Can the court dismiss the action based on any of these grounds without the filing of a motion to dismiss? Yes, it would seem so, because the second sentence says, when it appears from the pleadings or the evidence on record, the court shall dismiss the claim. Under the 1964 rules, one of the grounds that you can raise at any stage of the proceeding before judgment is failure to state a cause of action, but it disappears under the new rules. Does it mean to say that you cannot raise it anymore? No, it can still be raised because it can be taken care of by another rule, Rule 33 on demurrer. Section 2, compulsory counterclaim or cross-claim not set up, barred. A compulsory counterclaim or a cross-claim not set up shall be barred. This was illustrated under Rule 6, Section 7 and 8 on counterclaim and cross-claim, respectively. Rule on default, Section 3. If the defending party fails to answer within the time allowed, therefore, the court shall, upon motion of the claiming party, with notice to the defending party and proof of such failure, declare the defending party in default. Thereupon, the court shall proceed to render judgment, granting the claimant such relief as his or her pleading may warrant, unless the court, in its discretion, require the claimant to submit evidence. Such reception of evidence may be delegated to the clerk of court. The rule on answer is found under Rule 11. Section 1. Answer to the complaint. The defendant shall file his or her answer to the complaint within 30 calendar days after service of summons, unless a different period is fixed by the court. It is the failure of the defendant to answer within the proper period, not his failure to appear, nor failure to present evidence, which is the basis of a declaration of default. It does not occur from the failure of the defendant to attend either the pre-trial or the trial. If the period to answer lapses and there is no answer, the plaintiff will move to declare the defendant in default on the ground of failure to file an answer to the complaint. So the court will issue an order of default declaring him as a defaulted defendant. The defendant's non-appearance in the hearing and the failure to adduce evidence does not constitute default when an answer has been filed within the reglementary period. The failure of the defendant to attend the hearings for the presentation of the evidence of the adverse party amounts not to a default, but to a waiver of the defendant's right to object to the evidence presented during the hearing and to cross-examine the witnesses presented. However, it would not amount to a waiver of the defendant's right to present evidence during the trial dates scheduled for the reception of evidence for the defense. It is error for the court to issue an order not denominated as an order of default, but provides for the application of the effects of default as when the defendant who has filed an answer is not allowed to present evidence because of her absence during the presentation of evidence by the plaintiff. Monson Spouses, Relova versus Adio Properties, GR 1712827. Requisites before a party may be declared in default. 1. The court must have acquired jurisdiction over the person or the defendant through a valid service of summons or voluntary appearance. The defending party must have failed to file his answer within the reglementary period or within the period fixed by the court. 3. There must be a motion to declare the defendant in default. 4. The defending party must be notified of the motion to declare him in default. 5. There must be a hearing of the motion to declare the defendant in default, and 6. There must be proof of such failure to answer. Where no defaults are allowed: 1. Annulment of marriage. 2. Declaration of nullity of marriage. 3. Legal separation. 4. Special civil actions of certiorari, prohibition, and mandamus, where comment instead of an answer is required to be filed. And 5. Summary procedure. The required hearing is mandated by Section 4 of Rule 15, which states, hearing of motion, except for motions which the court may act upon without prejudicing the rights of the adverse party, every written motion shall be set for hearing by the applicant. Failure to file an answer under Rule on Summary Procedure. Under this rule, the defendant is not supposed to be declared in default. Instead, the court motu proprio, or on motion of the plaintiff, shall render judgment not to declare the defendant in default, as may be warranted by the facts alleged in the complaint and limited to what is prayed for. This represents a principal distinction between default in regular civil proceedings and the rule on summary procedure. Also, under the rule on summary procedure, the plaintiff is prohibited from filing a motion to declare the defendant in default. Section 19. 1991 Rule on Summary Procedure. Effect of a declaration or order of default. 1. The party declared in default loses his standing in court. The loss of such standing prevents him from taking part in the trial. Number 2. While the defendant can no longer take part in the trial, he is nevertheless entitled to notices of subsequent proceedings. It is submitted that he may participate in the trial, not as a party, but as a witness. 3. A declaration of default is not an admission of the truth or the validity of the plaintiff's claim. Monarch Insurance v. CA 333 Scra 7. Blason Enterprises Corporation v. CA 310 Scra 26. Take note that the word defending party applies not only to the original defendant, but even to the cross-defendant or defendant in a counterclaim. Action of the court after the declaration or order of default. It can do either of the following: 1. To proceed to render judgment, or 2. To require the plaintiff to present his evidence ex parte. Suppose the defendant filed an answer, but during the trial he failed to appear. May he be declared in default? No, because the ground for default is failure to file an answer. The correct procedure is for the trial to proceed without him. Go Changko versus RULE9 C. Chango. Chang-ho. Aiden Field 405. That is what you call ex parte reception of evidence. Only one side will be heard. Bar question. If the defendant is declared in default for failure to file an answer, is he deemed to have admitted the allegations in the complaint to be true and correct? Yes, because the law now says the court shall proceed to render judgment granting such claim as such relief as his pleading may warrant. The reception of plaintiff's evidence is already dispensed with. That is the general rule. That is the same as the summary rules and judgment on the pleadings, and the court can grant the relief without presentation of evidence. However, under Section 3, it is discretionary upon the court to require the claimant to submit evidence. Ex parte reception of evidence is optional for the court, and such reception of evidence may be delegated to the clerk of court. This is related to Section 9, Rule 30. The reception of evidence may be delegated to the clerk of court, but the clerk of court must be a lawyer. That is the condition. So if he is not a member of the bar, he is not authorized to conduct or hear an ex parte reception of evidence. Summary steps when the defendant fails to file an answer within the time allowed. 1. Motion to declare defendant in default. 2. Declaration or order of default. And 3. Rendition of judgment by default or judgment based on the complaint of the plaintiff unless court requires the claimant to submit evidence. Ex parte presentation of plaintiff's evidence. If a defendant files an answer but did not furnish a copy of the answer to the plaintiff, can the plaintiff move to declare the defendant in default? Yes, because the answer is deemed to have not been legally filed. It was not in accordance with the rules of court, Gonzalez versus Francisco. So the defendant must furnish the plaintiff a copy of the answer because, in the case of Ramirez versus Court of Appeals, held, the failure to furnish a copy of the answer to the adverse party in itself is sufficient or valid basis for defendant's default. Effect of pendency of a motion to dismiss or for bill of particulars. May a defendant be declared in default while a motion to dismiss Rule 16 or a motion for bill of particulars Rule 12 remains pending and undisposed of? No, because under the filing of a motion to dismiss or motion for bill of particulars interrupts the running of the period to answer. It will run again from the moment he receives the order denying his motion to dismiss or for bill of particulars. Hernandez versus Clapis, 87 Phil 437. But said motions must follow the requirements, otherwise they will be treated as mere scrap of paper and will not toll the running of the period to answer. In the case of Del Castillo versus Aguinaldo, 212-169. Facts. The defendant filed a motion to dismiss under Rule 16, but his motion to dismiss did not contain notice of time and place of hearing, and the motion was denied. Can he file an answer after filing the motion to dismiss? No. He can be ordered in default. The motion is a useless piece of paper with no legal effect. Any motion that does not comply with Rule 16 should not be accepted for filing, and if filed, is not entitled to judicial cognizance and does not affect any reglementary period. Not having complied with the rules, the motion to dismiss filed by the defendant did not stay the running of the reglementary period to file an answer. Golden Country Farm versus Sanvar Development Corporation. Facts. Because of the filing of the motion to dismiss is 15 days, the defendant filed a motion to dismiss on the 18th day. It was denied. So there is still 7 days to file an answer. On the 15th day, instead of filing an answer, he filed a motion for reconsideration, but such motion was also denied. Can he still file an answer? No. The filing of the motion to dismiss interrupted the period to file an answer. Illustration. When you received an order, you still have the balance to file your answer. And you did not file an answer. Instead, you filed a motion for reconsideration. You took the risks. So defendant's motion for reconsideration, which merely reiterated his ground in the motion to dismiss, did not stay the running of the period to file an answer. Answer filed out of time may be admitted. Where there is no declaration of default, answer may be admitted even if filed out of time. Where answer has been filed, there can be no declaration of default anymore. Guillermo Sablas versus Estrelita Sablas and Rodolfo Sablas. GR 144568. Effect of order of default. If you are declared in default, you cannot take part in the trial. You lose your standing in court. You cannot cross-examine the witness of the plaintiff, assuming there is a reception of evidence. You cannot object to his evidence. You cannot even present your own evidence when you are in default. Right of a party in default. He is entitled to notice of 1. Motion to declare him in default, order declaring him in default, 3. Subsequent proceedings, and 4. Service of final orders and judgments. Note, a defendant declared in default cannot take part in the trial, but he cannot be disqualified from testifying as a witness in favor of non-defaulting defendants. Cavilla versus Florendo. GR 73039. If the defendant was declared in default upon an original complaint, the filing of the amended complaint results in the withdrawal of the original complaint. Hence, the defendant is entitled to file an answer to the amended complaint as to which he was not in default. Judicial discretion to admit answer filed out of time. It is within the sound discretion of the trial court to permit the defendant to file his answer and to be heard on the merits after the reglementary period for filing the answer expires. The rules of court provides for discretion on the part of the trial court, not only to extend the time for filing an answer, but also to allow an answer to be filed after the reglementary period. It is not correct to say that the trial court has no recourse but to declare a defending party in default when he fails to file an answer within the required period. In fact, the rule is that the answer should be admitted where it is filed before a defending party is declared in default, and no prejudice is caused to the other party, and that there is no showing that the defendant intends to delay the case. Sublus versus sublus. The Hornbook rule is that default judgments are generally disfavored. Paramount Insurance versus AC Ordonez Corporation. Current judicial trend on default. The current judicial trend is to avoid defaults, and thus courts are enjoined to be liberal in setting aside orders of default. Ampelocchio versus CA 333 Scruff 465. The issuance of orders of default should be the exception rather than the rule, and to be allowed only in clear cases of obstinate refusal by the defendant to comply with the orders of the trial court. Lorvis versus CA. Because suits should as much as possible be decided on the merits and not on technicalities. Sammartino versus Braun, GR 131482. Thus, in practice, an answer under oath containing the defense of the defendant may, under the rules on liberal interpretation, be deemed as equivalent of an affidavit of merit. The policy of the law is to have every litigant's case tried on the merit as much as possible. Hence, judgments by default are frowned upon. A case is best decided when all contending parties are able to ventilate their respective claims, present their arguments, and adduce evidence in support thereof. Sublus versus sublus. And by the way, if you're not already subscribed, please do me a favor and hit that subscribe button. It's totally free, and it makes me really feel good about doing all this. Thank you. How to lift order of default. What is the remedy of a defendant who has been declared in default? One remedy under Section 3, Paragraph B is that, provided there is still no default judgment, he can still file a motion to set aside the order of default upon a proper showing that his failure to answer was due to fame, fraud, accident, mistake, or excusable negligence, and that he has a meritorious defense. To illustrate, even if you are a victim of fame, if you have no meritorious defense, the court will not lift the order of default. Upon proof, the court will set aside or lift the order of default and will give the defendant an opportunity to answer, where he will plead his supposed meritorious defenses. In effect, he regains his standing in court. When can the defendant avail of this remedy? He may file a motion to set aside the order of default at any time after notice thereof and before judgment. Summary steps the defendant should take to set aside the order of default. 1. File a motion to lift or set aside the order of default. The motion must be verified and under oath. 2. He must explain why he failed to answer due to fame. And 3. He must also show that he has a meritorious defense. In such a case, the order of default may be set aside on such terms and conditions as the judge may impose in the interest of justice. Remedy after judgment and before judgment becomes final and executory. The defendant may file a motion for new trial under Rule 37. He may also appeal from the judgment as being contrary to the evidence or the law. Palsan Enterprises versus Baliwag Transit. Remedy after the judgment become final and executory. The defendant may file a petition for relief from judgment under Rule 38, Balancad versus Justices of the CA, GR 83888. Where the defendant has, however, been wrongly or improvidently declared in default, the court can be considered to have acted with grave abuse of discretion amounting to lack of jurisdiction, and when the lack of jurisdiction is patent in the face of the judgment or from the judicial records, he may avail of the special civil action of certiorari under Rule 65, Balancad versus Justices. Implied lifting of the order of default. While it is true that there was no positive act on the part of the court to lift the default order because there was no motion nor order to that effect, the anti-graft court's act of granting respondent the opportunity to file a responsive pleading meant the lifting of the default order in the interest of justice. Partial default. When a pleading asserting a claim states a common cause of action against several defending parties, some of whom answer and the others fail to do so, the court shall try the case against all upon the answers thus filed and render judgment upon the evidence presented. Illustration. This presupposes that there are two or more defendants. Say one or some of the defendants made an answer and the others did not. So one or some of the defendants were declared in default, the others were not. Example, Gary sued Bentong and Bayani. Bentong filed an answer, Bayani did not. Bayani was declared in default, but there can be no judgment against Bayani in the meantime because under paragraph C, the case will go to trial based on the answer of Bentong. The case will be tried against both Bentong and Bayani based on the answer of Bentong. The principle here is that the answer filed by the answering defendant will automatically benefit the non-answering defendant. The defense of Bentong will also be Bayani's defense. Anyway, there is a common or identical cause of action. Effect of partial default. In all instances where a common cause of action is alleged against several defendants, some of whom answer and the others do not, the latter, or those in default, acquire a vested right not only to own the defenses interposed in the answer of their co-defendant or co-defendants not in default, but also to expect a result of the litigation totally common with them in kind and in amount, whether favorable or unfavorable. Remedia Grajida et al. Versus Honorable Nympha Gomez and Houdini Grajida, GR 169536. The best example would be a promissory note signed by both Bentong and Bayani, and they bound themselves solidarily. Both of them were sued. Bentong answered while Bayani did not. Hence, he is in default. Can there be a default judgment against Bayani? No. There will still be a trial based on the answer of Bentong. In effect, Bentong will defend not only himself but also Bayani. Suppose during the trial, Bentong proved that the obligation has been extinguished, which is also applicable to Bayani, and the complaint is dismissed. What is the effect? Both Bentong and Bayani will win the case. So Bayani will be benefited by the answer of his co-defendant Bentong. Hence, there is still a possibility that the defaulted defendant can win based on our example. On the other hand, it is absurd if the answer of Bentong will not benefit the defaulting defendant. Example, Gary filed a case against Bentong and Bayani based on the promissory note on a loan secured by both, and Bayani defaulted. Bentong answered alleging payment. Suppose Bentong proved such defense. The effect is both Bentong and Bayani are absolved. If you say that Bayani should lose because the answer of Bentong will not benefit Bayani, there will be two conflicting decisions. Bayani is in default and thus should pay the loan, and there is no more loan as far as Bentong is concerned. Do you mean a loan is paid and at the same time unpaid? In the case of Ku versus Acosta, 134 Scra 185, reiterating the case of Lim Tanhu versus Ramolete, 66 Scra 425, facts. Bentong and Bayani were solidary debtors sued by Gary for loan evidence by promissory note. Bentong filed an answer but Bayani defaulted. The case was tried based on Bentong's answer. Gary moved to drop Bentong from the case but retained Bayani, the defaulted defendant, so that Gary can secure an immediate judgment. Issue: is the motion of Gary proper? Held no. When there is a common cause against two or more defendants, if you drop the case against one, you drop the case against all. Selection is not allowed. To drop Bentong means that the cause of action against him is weak. Why should one drop somebody if a case against such person is meritorious? If such is the fact, necessarily the cause of action against the other is also weak. The fact there is actually a common cause of action. However, the ruling in Acosta should not be confused with the ruling in Imson versus CA. Facts. Imson was driving a Toyota Corolla when he was bumped by a Hino truck, causing injury to Imson and totally wrecking his car. So he filed an action for damages against several defendants. He impleaded all of them: the driver, the bus company owner, and the insurance company. The insurance company filed an answer, but the owner and the driver did not. So both the owner and the driver were declared in default. Subsequently, Imson and the insurance company entered into a compromise agreement wherein the latter paid him $70,000, which was its total liability under the insurance contract, but constituted only a part of the total claim. So when the case between Imson and the insurance company was eventually dismissed because of the compromise agreement, the bus company owner also moved to dismiss the case against him and the driver, arguing that since they are all indispensable parties under a common cause of action, the dismissal of the case against the insurance company should likewise result to the dismissal of the case against them, citing the case of Acosta and Ramolete. Issue number 1. Is there a common cause of action among the three of them? Held. The owner is wrong. There is no common cause of action. The cause of action against the driver is based on quasi-delict under Article 2178 of the Civil Code. The liability against the owner is also based on the quasi-delict, but on another provision of the Civil Code, Article 2180. The liability of the employer for the delict or wrong of the employee. So the liability of the owner and the driver is based on quasi-delict, but under separate provisions of the Civil Code. Now, the cause of action against the insurance company is not based on quasi-delict, but based on a contract, because he seeks to recover liability from the insurance company based on the third-party liability clause of the insurance contract with the company. So there is no common cause of action among them. Issue number 2. Is the insurance company an indispensable party? Because if it is so, and he is removed from the case cannot proceed without him. Held? No. The insurance company is not an indispensable party. It is true that all of Imson's claims in civil cases premised on the wrong committed by defendant truck driver. Conceitedly, the truck driver is an indispensable party to the suit. The other defendants, however, cannot be categorized as indispensable parties. They are merely necessary parties to the case. It is easy to see that if any of them had been impleaded as defendant, meaning the insurance company or the owner was impleaded, the case would still proceed without prejudicing the party not impleaded. Thus, if petitioner did not sue the insurance company, the omission would not cause the dismissal of the suit against the other defendants. Even without the insurer, the trial court would not lose its competence to act completely and validly on the damage suit. The insurer clearly is not an indispensable party. It is a necessary party. D is extent of relief to be awarded. This is what we call limitations on a default judgment. The default judgment should not exceed the amount prayed for in the complaint. The default judgment should not be different in kind from that prayed for in the complaint. The default judgment should not award unliquidated damages. Extent of relief in a judgment by default. If the complaint seeks to recover $1 million, but the evidence of the plaintiff shows the right to recover $1.5 million, the court has no authority to grant the latter amount, despite the evidence. This is because under the rules, a judgment rendered against a party in default shall not exceed the amount, or be different in kind from that prayed for, nor award unliquidated damages. Section 3, Velason v. CA 310-26. In the complaint, the claim is $300,000. The defendant defaulted. The court required the plaintiff to present his evidence, and during the trial, the latter proved $500,000 total claim. Can the court award $500,000 claim as proved? No. It should only be 300,000 as prayed for in the complaint. Suppose during the trial only 200,000 was proved. What should be the amount of the default judgment? Only 200,000 as proved because it did not exceed the amount prayed for in the complaint. Therefore, the rule is the default judgment cannot exceed the amount prayed for in the complaint, although it may be less than it. Fundamental reason and the rule on default. What is the reason behind this? In the case of Lim Toko versus Go Fei, 80 Phil 166, there were two possible reasons. One, defendant deliberately did not answer because he believed that he had no good defense and that the claim is fair. And if he will make an answer, still he will not win and would just incur expenses. Number two, he had a meritorious defense and he wanted to answer, but for one reason or another, beyond his control, he failed to file his answer. In the second possibility, the defendant had a defense and wanted to file an answer but failed to file an answer. What is the remedy of such defendant? It is, in paragraph B, file a motion to lift the order of default and state the reasons beyond one's control, fraud, mistake, accident, or excusable negligence, and that there is a meritorious defense. Now suppose he did not answer because he thinks the claim is fair and so he will just pay. Then the contingency is paragraph D. Rest assured that the judgment will not exceed the amount or be different in kind from that prayed for. At least you will not be surprised. If the defendant filed an answer but failed to appear during trial, what will happen? The case will proceed and there will be a presentation of evidence ex parte. Now, if a person is declared in default, it is also possible that an ex parte presentation of evidence will be ordered. Mangalin versus CA issue. What is the difference between ex parte presentation of evidence by virtue of default judgment and ex parte presentation of evidence by failure to appear during the trial? Held in reception of evidence due to default order, paragraph D applies. The judgment cannot exceed the amount or be different in kind from that prayed for in the complaint. But if there is an ex parte reception of evidence against a defendant who filed an answer but failed to appear during trial, the limitations in paragraph D does not apply. Therefore, in this case, a greater amount than that prayed for in the complaint or a different nature of relief may be awarded so long as the same are proved. It may be pointed out that there is a difference between a judgment against a defendant based on evidence presented ex parte pursuant to a default order and one based on evidence presented ex parte and against a defendant who had filed an answer but who failed to appear at the hearing. In the former, Section 3, letter D of Rule 9 provides that the judgment against the defendant should not exceed the amount or be different in kind from that prayed for. In the latter, however, the award may exceed the amount or be different in kind from that prayed for. This is because when there is an ex parte presentation of evidence due to failure to appear in court, one's standing in court is not lost. He can still present evidence later to refute the plaintiff's evidence. He simply waived the rights attached on particular hearing, but not to all subsequent trials. In judgment by default, he actually loses his standing in court. They added a new third limitation: unliquidated damages cannot be awarded in default judgment. Obviously, liquidated ones can be. What is the difference between unliquidated damages and liquidated damages? Unliquidated damages are those which are still subject to evidence before it can properly be awarded, such as the presentation of receipts in terms of actual damages or taking of testimonies to determine mental anguish or besmirch reputation in case of moral damages. Liquidated damages are those which are already fixed and proof or evidence to establish the same are not required. An example is an obligation with a penal clause, like an agreement to construct a house, and upon failure to finish the same within a stipulated period, the contractor is liable for $10,000 for every day of delay. The amount is already fixed based on the contract price and the penalty provided in such other circumstances as stipulated. So in an action for unliquidated damages, let the defendant be declared in default anyway, the court can never award those damages. To illustrate, if I will answer, damages can be awarded. In other words, I will win the case simply because there is no way for the court to award the damages. And most damages are usually those unliquidated damages. Letter E, where no defaults allowed. This refers to marital relations referred to in the family code, annulment of marriage, declaration of nullity of marriage, legal separation, and the policy of the state is to preserve the marriage and not encourage breakups. Now, in the absence of this provision, husband and wife quarrels and then they decide to separate. Wife will file a case for legal separation with the agreement that the husband will not answer. Being in default, there will be a judgment in default, and in a month's time, marriage will be severed for the meantime. The provision then prohibits default in marital relations cases to preserve and uphold public policy. Relate this provision to the rule to Article 48 and 60 of the Family Code. Next is amendments, Rule 10. And if you're not already subscribed to me, please give me some love and hit that subscribe button. It's free and you get notified with all my audios. If you have any feedback or suggestions, please inbox me or leave me a comment. Thank you.